Former Governor Arnold Schwarzenegger is back with an amicus brief in a gerrymandering case that might decide whether state judiciaries have the power to override state legislatures when the legislature implements a gerrymandered map. Now, this is Moore v. Harper in North Carolina, and this is the North Carolina Supreme Court versus the North Carolina legislature, and it's going to be based on the North Carolina Constitution. So there are 49, 50, 51 other state constitutions that will govern whether the legislature and the judiciary operate in the exact same way as in North Carolina. So this is going to be a little specific to North Carolina, but since it's reached the Supreme Court, it's possible the Supreme Court could change something about the way this balance of power works. This is the checks and balances of government. How much power does the legislature have, and how much power does the judiciary have? And when one of them thinks the other one's done something wrong, how much power do they have to check or correct it? How much balance is there between the power? In case you've never heard of gerrymandering, gerrymandering is a way of drawing electoral district boundaries in a way to override the intent of the electors, the people. If you look at this crude example, maybe oversimplified a little bit, but it really illustrates what's going on here. If you have a state that is 60% blue and 40% yellow, you can get a yellow win by drawing the district boundaries in a disproportionate way. You can see on the right top, if you draw the boundaries in a way that overrepresents the blue districts in their districts and overrepresents the yellow districts in their districts, you can get the 40% yellow to overcome the 60% blue. It's a bit of mathematical trickery. Instead of measuring the outcome of an election by straight popular vote, you divide the popular vote into these districts. The districts then choose like the state legislatures and representatives and things like that. But then if you base the overall election of, say, the vote for president or something on gerrymandered districts, you can get, in this case, a minority yellow vote to overcome the blue majority vote. So then the issue in Moore v. Harper is whether the state's judicial branch, in this case North Carolina, may nullify the regulations governing the manner of holding elections for senators and representatives prescribed by the legislature, and then replace them with regulations of the state court's own devising. This is based on a vague, or arguably vague, state constitutional provision purportedly vesting the state judiciary with power to prescribe whatever it rules appropriate to ensure a free and fair election. And vagary in election laws can lead to weird results. Fortunately, there's a lot of common law. There's a lot of previous case law that says what happens here. Instead of me talking about it, let's hear from former Governor Arnold Schwarzenegger. So this is Governor Schwarzenegger's amicus brief in Timothy K. Moore versus Rebecca Harper. First, he states his interest in being an amicus curiae. Governor Schwarzenegger experienced firsthand the pernicious effects of partisan gerrymanders, from never-ending redistricting disputes to the partisan political atmosphere that results from gerrymanders. He has also had first-hand experience with state government reforms that can eliminate or at least minimize partisan gerrymanders. In 2008 and 10, Governor Schwarzenegger successfully advocated for two ballot initiatives discussed below that established a nonpartisan redistricting commission for California's legislature, Board of Equalization, and U.S. House members. These reforms ended decades of partisan gerrymanders to the benefit of California citizens and political system. Governor Schwarzenegger retains a continuing interest in the survival and success of these reforms. Introduction. The American constitutional tradition of checks and balances is informed by centuries of political thought and experience. Consistent with that tradition, states have developed careful balances in their constitutions to allocate and constrain the exercise of legislative power under the Elections Clause in order to combat the pernicious effects of partisan gerrymanders. And they have relied on more than a century of this court's precedent upholding their ability to do so. Among other checks and balances, 10 states now assign congressional redistricting to commissions that are less beholden to self-interested partisan politicians and that are prohibited by law from enacting partisan gerrymanders. This court favorably cited these independent commissions as a way in which states are actively addressing the problems of excessive partisan gerrymandering in Rucho versus Common Cause in 2019. Petitioners' theory of the Elections Clause. So, petitioner is Timothy K. Moore in his official capacity as the Speaker of the North Carolina House of Representatives. Petitioners' theory of the Elections Clause posits that state legislatures may act independently of these state constitutional provisions when exercising powers under the Elections Clause. This theory would eliminate state efforts to curtail partisan gerrymandering, imperiling the checks and balances needed for a functioning redistricting process that places voters' interests over legislators. It would upset this court's long-standing precedent upholding states' checks and balances on the exercise of legislative power for congressional redistricting through popular referenda, gubernatorial vetoes, and independent redistricting commissions. And the theory itself is incoherent and standardless. It admits that some state constitutional provisions continue to apply to states' exercise of powers under the Elections Clause, but arbitrarily excludes other provisions. This court should adhere to its precedents upholding state-level checks and balances because those precedents were correctly decided. They have engendered significant reliance by states that have organized their self-governance around them, and our political system would suffer harm if partisan gerrymanders were left entirely without state-level checks and balances. The California Citizens Redistricting Commission, the type of commission cited favorably in Rucho, illustrates why. As governor of California, Amicus Arnold Schwarzenegger took the lead in urging voters to approve the constitutional amendments creating the commission so that California could move beyond a shameful history of partisan gerrymandering that yielded frequent deadlocks, embroiled courts, and disturbed the public. Millions of Californians voted to create this commission. It has improved California's maps by neutral standards while avoiding the self-serving map drawing and partisan conflicts of past redistricting cycles. In 2021, the commission, with 5 Republican, 5 Democrats, and 4 independent commissioners, unanimously approved the Senate's legislative maps. Petitioners' Elections Clause theory would call into serious question this well-functioning body and create the specter that California would have to revert to the divisive and dysfunctional redistricting process of the past. This court should reject that theory and affirm the decision below. Argument. State constitutional provisions constrain states' exercise of legislative power under the Elections Clause. This court's precedents uphold the applicability of state constitutions. The Elections Clause provides that the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. The text of that provision is silent as to whether other sources of state law may constrain the legislature thereof in the exercise of its powers. But this court's, the Supreme Court of the United States, precedents are not silent. In 3 cases spanning a century, this court has held that the state legislature thereof is bound by state constitutional provisions. These decisions reflect the fundamental principle that a state legislature is an entity created and constrained by the state constitution. In Ohio, X. Rel. Davis versus Hildebrandt in 1916, this court rejected an Elections Clause challenge to an Ohio constitutional provision allowing the people to vote down congressional redistricting plans by popular referendum. This court explained that the referendum constituted a part of the state constitution and laws and was contained within the legislative power. The state constitutional referendum provision thus constrained the state's exercise of power under the Elections Clause. In Smiley versus Holm in 1932, the Minnesota Supreme Court had adopted the independent state legislature theory that is advanced here to reject a gubernatorial veto of a congressional redistricting plan. Quote, "The word legislature has reference to the well-recognized branch of the state government, and when the framers of the federal Constitution employed this term, we believe that they made use of it in the ordinary sense with reference to the official body invested with the functions of making laws, the legislative body of the state, that they did not intend to include the state's chief executive as a part thereof." This court reversed because neither the text of the Elections Clause nor the original intent behind that provision displaced the principle that the exercise of the state legislative authority must be in accordance with the method which the state has prescribed for legislative enactments. And finally, in Arizona State Legislature versus Arizona Independent Redistricting Commission in 2015, this court upheld an Arizona constitutional provision enacted by popular ballot that removed congressional districting authority from the state legislature, lodging that authority instead in a new entity, the Arizona Independent Redistricting Commission. There, both the majority and Chief Justice Roberts' dissent agreed that state constitutional provisions may properly constrain the exercise of states' legislative powers under the Elections Clause. Quote, "It is characteristic of our federal system that states retain authority to establish their own governmental processes." And then Roberts dissenting, agreeing with the straightforward rule that the legislature is a representative body. When it prescribes election regulations, it may be required to do so within the ordinary lawmaking process as set forth in the state constitution. Recently, in Rucho v. Common Cause, 2019, this court relied on that principle from those prior decisions. This court explained that its decision regarding the non-justiciability of federal constitutional challenges to partisan gerrymanders did not condemn complaints about districting to echo into a void, because states are actively addressing the issue on a number of fronts. The court proceeded to cite favorably state constitutional provisions affecting states' exercise of legislative power under the Elections Clause, including voter-approved constitutional provisions prohibiting gerrymandering. Quoting the Florida Constitution, "No apportionment plan or individual district shall be drawn with the intent to favor or disfavor a political party or an incumbent," and creating independent redistricting commissions like the one in Arizona State Legislature. Davis, Smiley, and Arizona State Legislature were correctly decided, and Rucho persuasively relied upon state-level innovations to combat partisan gerrymanders. The principle of those decisions, that states' legislative powers are created and constrained by state constitutions, is consistent with the framers' original intent and with historical practice shortly before enactment of the Constitution. Now, it's important that he brings up original intent because we have a bunch of constitutional originalists in the majority of the Supreme Court, which is how we got the overturning of Roe v. Wade. The constitutional originalist argument in Dobbs was that abortion wasn't a right originally in the Constitution, and so we don't read into the rights of life, liberty, and pursuit of happiness, or read into the rights of due process or something. We don't read a privacy right into that, and we don't read a abortion right into that as a privacy right. Wasn't in the Constitution, therefore doesn't exist. So by addressing that, for this Supreme Court, Schwarzenegger is tailoring the argument, hoping that the originalists will side with him, because this is a much more established right than the argument over abortion. At the time of the Constitution's enactment in 1787, the nation was operating under the Articles of Confederation, which had a similarly worded predecessor to the Elections Clause. The Articles of Confederation provided that delegates to the Congress shall be annually appointed in such a manner as the legislatures of each state shall direct. The contemporaneous understanding of this provision was that the state legislatures were constrained by their state constitutions when selecting delegates to the Continental Congress that promulgated the Articles of Confederation. 10 of 11 state constitutions, including North Carolina, in effect between 1776 and 1787, imposed such constraints. See North Carolina Constitution of 1776, that the delegates for this state to the Constitutional Congress, while necessary, shall be chosen annually by the General Assembly by ballot, but may be superseded in the meantime in the same manner, and no person shall be elected to serve in that capacity for more than 3 years successively. Moreover, during this period, there was a prevailing practice and view that these constitutional constraints would be enforced through judicial review. The Elections Clause, the Federal Elections Clause, drafted in 1787, closely mirrors the text of Article 5 of the Articles of Confederation. Compare U.S. Constitution Article 1, Section 4, electoral regulations shall be prescribed in each state by the legislature thereof, with the Articles of Confederation, Article 5, delegates appointed in such manner as the legislatures of each state shall direct. As this court has noted, whether the Elections Clause imposed limitations on the legislative processes by which the states could exercise their initiating role in regulating congressional elections occasioned no debate by the framers. The framers' choice of nearly identical language for the Elections Clause and the Articles of Confederation indicates they intended the established understanding of Article 5 to carry forward with the Federal Elections Clause, and that is what happened. In the decades following the Constitution's enactment, the large majority of state constitutions constrained state legislatures' exercise of power under the Elections Clause. That practice continued throughout the 1800s. In one more recent example, 13 states adopted women's suffrage by constitutional amendment in advance of the 19th Amendment. Those venerable efforts would have been unconstitutional under Petitioners' theory here. More generally, the independent state legislature theory also would have been antithetical to the framers' prevailing views. The framers well understood the necessity of retaining checks and balances on the legislature. Quote, "It is against the enterprising ambition of this department that the people ought to indulge all their jealousy and exhaust all their precautions." From the Federalist number 48 by James Madison. And they viewed judicial enforcement of constitutional constraints as keeping the legislature within the limits assigned to its authority. From the Federalist number 78 by Alexander Hamilton. Quote, "Where the will of the legislature, declared in its statutes, stands in opposition to that of the people, declared in the Constitution, the judges ought to be governed by the latter, rather than the former." There is no basis to believe the framers abandoned those views and the contemporaneous practices of states to single out the Elections Clause as an instance in which legislatures were granted exclusive powers without checks and balances, and that they did so without any recorded debate. Petitioners' independent state legislature theory would upset established precedent. Petitioners urge this court to adopt the independent state legislature theory of the Elections Clause. Petitioners' brief says, inherently legislative decisions about the manner of federal elections in a state are committed to the legislature thereof, and Constitution places the regulation of federal elections in the hands of state legislatures, Congress, and no one else. In petitioners' view, any delegation of a state legislature's authority to regulate congressional elections to another entity is unconstitutional under the Elections Clause. Thus, the only check against any potential abuse by the state legislature is congressional review, federal congressional review. Petitioners' theory cannot be squared with this court's long-standing precedent that faithfully implements the framers' intent. Their theory means that the citizens of a state cannot override the legislature's congressional map by popular referendum, which is contrary to Davis v. Hildebrandt. A governor cannot veto a legislature's congressional map, contrary to Smiley v. Holm, and voters cannot assign congressional redistricting to an independent commission, contrary to Arizona state legislature. Indeed, the theory renders states incapable of imposing any constitutional restrictions on their legislature's natural proclivity to gerrymander, contrary to Rucho's recognition of many such innovative ways states have been addressing actively those problems. And there you have it. It took a bunch of pages to get there, but that's why we were doing all that talking about Rucho and Davis and Smiley and Arizona. We got there. Petitioners attempt to avoid the inevitable consequences of the independent state legislature theory by making a remarkable concession. They, quote, "do not dispute that each state's constitution may properly govern such procedural questions as whether a bicameral vote is required to enact a law, whether the legislation is subject to a gubernatorial veto or veto by governor, and perhaps in the extreme case whether some lawmaking entity other than the ordinary institutional legislature has authority to legislate on the subject." I guess they mean agencies? Petitioners must make this concession because, as they acknowledge, quote, "the federal constitution, of course, does not create the state legislatures themselves. State constitutions enacted by the people decide which bodies exercise legislative powers and what constraints are imposed on those legislative bodies, as this court held in Davis, Smiley, and Arizona state legislature. Having conceded that some state constitutional provisions must continue to apply to states' exercise of legislative powers under the Elections Clause, petitioners have no basis to exclude other state constitutional provisions. They seek to draw a distinction between state constitutional provisions that concern procedural questions, which are permissible, and those that impose substantive limits, impermissible. Kinda strange, they are admitting that there's a substantive something to be read into procedural laws. Wasn't that the Dobbs problem? But they offer no coherent theory to justify that distinction or standards to evaluate the constitutionality of future limits. Their argument begins and ends with the text of the Elections Clause, and the text of that clause does not draw any distinction between procedure and substance. Nor do petitioners cite any historical support for their distinction. The distinction would lead to absurd textual inconsistencies within the Elections Clause. The first half of the clause provides that electoral regulations shall be prescribed in each state by the legislature thereof, and the second half provides Congress may at any time, by law, make or alter such regulations. There is no reason why petitioners' distinction would not apply to both halves of the Elections Clause, and if so, Congress could make or alter election regulations unbounded by any substantive provision in the rest of the federal Constitution, presumably including the First and 14th Amendments. Nor do petitioners provide a workable rule for dividing procedure from substance. They argue that state judicial review of congressional redistricting seizes the power to regulate the manner of congressional elections, and thus falls on the substance side of the ledger. But judicial review no less seizes the power to regulate than a governor vetoing a map, the public rejecting a map by referendum, or the public vesting congressional redistricting power in an independent commission by initiative, all of which supposedly fall on the procedure side of the ledger. Petitioners' dividing line has no guiding principle. It is drawn solely to achieve their desired outcome here, much like a gerrymandered electoral districting map. Stare decisis should compel this court to reject petitioners' invitation to overrule well-established precedent. This court should reject petitioners' invitation to overrule long-standing precedent to the extent that it is not distinguishable. This court should be guided by stare decisis, an established rule to abide by former precedents, where the same points come again in litigation, as well to keep the scale of justice even and steady, and not liable to waver with every new judge's opinion. Stare decisis is the principle that we follow the consistency of former opinions. So, long-standing rule of law is X, well, we follow X. We don't just change it without a really, really, really good reason. Most of the time, courts will side with stare decisis and say the legislature has to override long-standing court precedent. So if the legislature hasn't overridden long-standing court precedent in some valid way, and this gets complicated because here we have a legislature that's trying to override court precedent, and they're trying to do so by saying the Constitution supports this, and of course, the courts are going to say the Constitution doesn't support this, or at least that's Governor Schwarzenegger's argument. So there's this tug of war of power, and who actually has it. We have to solve this in some civilized way, and the Supreme Court of the United States is sort of the final place to solve that in a civilized way. If we can't solve it in a civilized way here, the solving of it may not be very civilized. This respect for precedent promotes the even-handed, predictable, and consistent development of legal principles, fosters reliance on judicial decisions, and contributes to the actual and perceived integrity of the judicial process. The question today is not whether Davis, Smiley, and Arizona State Legislature were right or wrong, but whether to adhere to them in deciding the present case. For precedent to mean anything, the doctrine must give way only to a rationale that goes beyond whether the case was decided correctly. To overrule this court's precedents, there must be a special justification that remains true even for constitutional decisions where the doctrine of stare decisis is not as inflexible. See Ramos versus Louisiana, Justice Kavanaugh concurring, in part, quote, Three broad considerations help guide the inquiry and help determine what constitutes a special justification or strong grounds to overrule a prior constitutional decision. Each of these considerations weighs against petitioners. First, Davis, Smiley, and Arizona State Legislature are not grievously or egregiously wrong. They stand on the firm principle that a state may enact constitutional checks and balances on the exercise of the state's legislative power. That principle is workable and guides the proper result in this case. North Carolina's Constitution vests the legislative power in the General Assembly and the judicial power in a General Court of Justice. That judicial power includes judicial review of state legislative actions for compliance with the state constitution. The North Carolina Supreme Court thus acted consistently with this constitutional structure when it held the constitutional redistricting plan violated Articles 10, 12, 14, and 19 of the North Carolina Constitution. Petitioners attempt to show that their theory of the Elections Clause best accords with its original intent, but their claim that no state constitution appears to have imposed rules governing congressional districts is inaccurate. Respondents thoroughly demonstrate the flaws in petitioners' arguments. At the very least, this court's reading of that historical evidence in Smiley and Arizona State Legislature was not grievously or egregiously wrong. Second, these decisions have not caused significant negative jurisprudential or real-world consequences. These decisions allow states to impose checks and balances on congressional redistricting. These checks, particularly voter-approved state constitutional provisions like California's Independent Redistricting Commission, express the will of the people, which are the font of governmental power. That is a positive consequence of this court's decisions that should not be disturbed. But there would be serious negative consequences to adopting the independent state legislature theory without checks and balances. That theory deprives states of any ability to enact meaningful checks and balances on congressional redistricting to prevent harmful gerrymanders that prioritize partisan advantage or incumbent protection. Virtually all of the state's methods for actively addressing those gerrymanders discussed in Rucho would be rendered unconstitutional. The states would no longer serve their role as laboratories for devising solutions to difficult legal problems like partisan gerrymandering. Third, overruling these prior precedents would unduly upset reliance interests. In other words, your ability to rely on the consistency of the law. Many states have long-standing constitutional provisions that carefully allocate and constrain the exercise of state legislative power under the Elections Clause. Voiding those constitutional provisions will spawn litigation about the validity of the congressional maps currently in use. It will cause great uncertainty in upcoming election cycles about where congressional lines fall. This would be extraordinarily disruptive at any time, but especially so shortly on the heels of the 2020 decennial redistricting cycle. If existing congressional maps are invalid, new maps may need to be redrawn for a second time in a matter of years wherever state constitutional provisions have constrained the state legislature's redistricting power. Overruling any of Davis, Smiley, and Arizona State Legislature's provisions would cause significant harm to our political system. Partisan gerrymanders threaten our political system. They are incompatible with democratic principles. Instead of voters participating equally in the political process to choose their political representatives, self-interested politicians entrench themselves in office by choosing their voters. This insulates incumbents in safe districts, minimizing electoral competition, and heightens partisanship. State reforms to combat partisan gerrymandering cannot be effective if they cannot impose checks and balances on a self-interested state legislature's congressional redistricting powers, as did the referendum in Davis, the veto in Smiley, and the independent commission in Arizona State Legislature, and the state constitutional constraints cited favorably in Rucho. This need for checks and balances on state legislatures is informed by centuries of political thought and experience. The framers who crafted the Elections Clause, along with the rest of our Constitution, gleaned lessons from Revolution-era state constitutions that did not constrain their state legislatures with checks and balances. They knew well that many legal infractions of sacred right and many wanton abuses of legislative powers occur when state legislatures are left unchecked. But Petitioners' independent state legislature theory here rejects any state check or balance. Many states rely on independent commissions to address gerrymandering. In reliance on this court's precedents, 10 states have adopted nonpartisan or bipartisan commissions, independent of legislatures, to draw their congressional maps. Studies have shown that these independent commissions have significant benefits. Independent commissions generally produce less biased and more competitive plans than when one party controls the process, and ensure a consistent process from one redistricting cycle to the next, while also reducing the partisanship of congressional representatives. Recent studies based on more robust data show that independent commissions are 2.25 times more likely to have competitive elections and decrease incumbent party wins by 52%. California's commission is a model example of the success of these state reforms. Californians enacted the commission by ballot initiative to do away with decades of partisan gerrymanders. Governor Schwarzenegger was a strong proponent of the ballot initiative for the same reason that it resonated with millions of Californians. The commission would vest the power to create electoral districts in an independent commission consisting of qualified citizens that do not depend on gerrymanders to obtain their office. Before the commission, California was like many other states. Every decennial census brought a new opportunity to re-gerrymander the state's electoral districts to entrench one political party. Not only did these gerrymanders hurt California politics, but they tied up state courts for years. After the 1970 census, the Democratic legislature and Republican governor deadlocked, leading to the California Supreme Court appointing special masters to draw the maps after 2 years of stalemate and one election cycle without any redrawn maps after a census. After the 1980 census, a Democratic legislature and governor passed maps squeezing every last Democratic seat they could out of the process. But voters used their referendum power to reject the maps, requiring the legislature to redraw the maps in the middle of the campaign season. The California Supreme Court eventually was forced to draw temporary districts for the 1982 election. The 1990 census was followed by a recurrence of the impasse of the 70s, with a Republican governor vetoing a Democratic legislature's maps and the state Supreme Court needing to intervene by appointing special masters to draw maps. The map drawing after the 2000 census failed in a different way, an incumbency protective bipartisan gerrymander in which legislatures reached a deal that largely preserved the status quo by making districts less competitive, especially for Congress, while seeming to satisfy no one but its authors. This gerrymander harmed voters by maximizing the protection of incumbents while diluting the voting power of California's increasing numbers of voters of color. To illustrate the process following the 2000 census, a U.S. representative's brother charged California members of Congress $20,000 each to draw good seats, one of whom explained that $20,000 was a good investment compared to the $2 million typically spent on a re-election campaign. After decades of flawed redistricting, Californians decided that they had enough. In 2008, California voters approved Prop 11, the Voters First Act, which created the commission to conduct redistricting for the California State Assembly, Senate, and Board of Equalization. In 2010, California voters approved Proposition 20, the Voters First Act for Congress, extending the commission's authority to redistrict for the state's congressional seats. More than 6 million Californians voted in favor of the independent redistricting process in 2008. 2 years later, the Independent Redistricting Commission's authority was extended to congressional elections by a large margin, 61-39. In the same election, a similarly large margin rejected Proposition 27 that would have repealed the commission and returned redistricting to the legislature. Props 11 and 20 succeeded because their supporters built a broad bipartisan coalition before going to the voters. The successful votes in 2008 and 10 followed decades of unsuccessful efforts to win voter approval of redistricting bodies independent of the California legislature. In these past instances, voters discerned a partisan valence to each proposition, with the Republican Party in favor and the Democratic Party opposed. Unlike these prior unsuccessful propositions, Prop 11 was drafted by an extraordinarily wide range of potential stakeholders, which included Republicans, Democrats, businesses, unions, civil rights organizations, and good governmental groups, involving both supporters and oppositions of the failed 2005 proposition. I would like to know what the criteria is for determining which governmental groups are good. Its drafters learned from the political failures, replacing a reliance on judicial and partisan actors with citizen members carefully screened to eliminate possible connections to political office holders. In approving the commission, California voters exercised their initiative power enshrined in the California Constitution. The initiative power dates to 1911, when California's then governor promised voters he would create it. The legislature placed the proposed constitutional amendment on the ballot, and voters approved it. The Commission has imposed valuable checks and balances that protect voters' rights and interests. First, the Commission must use neutral redistricting criteria. It requires districting according to equal population, then Voting Rights Act compliance, then contiguity, then geographic integrity of cities, counties, and communities of interest, then compactness, and then nesting. Second, the selection process for the commission is designed to produce a commission that is independent from legislative influence. Its 14 members, 5 are from the largest party by registration, 5 from the second largest party, and 4 unaffiliated with a party. Third, the commission has a transparent process. They must explain the basis for their decision, and they can enact maps only with bipartisan support. In each of these respects, the California Commission resembles the Colorado and Michigan redistricting commissions that this court cited approvingly in Rucho. Moreover, assessments of the Commission's work confirm that it has improved California's map by traditional neutral standards. Its maps after the 2010 census were more competitive than the prior maps. Those maps significantly reduced split cities and counties compared to maps drawn by special masters and the legislature after the 1990 and 2000 census. Very quickly, here's some examples of weird gerrymanders. Here's North Carolina. You've got this district that goes from Charlotte up to Salisbury, up to Greensboro, through different counties, etc. You've got another one. It looks like Chapel Hill down to Fayetteville and out to Raleigh. These just look like really weird maps. Here's Philadelphia's, or one of Philadelphia's, catching parts of Lansdale all the way out to west of Coatesville and up to Reading. These places are hours of driving away from one another. To get from Philadelphia to Reading is about an hour and a half. To get to Lansdale is about an hour. To get to Coatesville is about an hour and a half. So these are large districts that are drawn in very strange ways. Those maps significantly reduced split cities and counties compared to the maps drawn by special masters and the legislature after the 1990 and 2000 censuses, respectively. Those maps were more congruent with geographic communities of interest than the districts they replaced. And the maps resulted in legislative diversity more closely matching California's population. In all respects, the Commission meaningfully improved California's maps compared to the traditional legislative process to which California would be returned under the new independent state legislature theory of petitioners in this case. This court should continue to allow states to actively address partisan gerrymanders, see Rucho, and should not terminate California's and other states' innovations and experimentation, as in Arizona state legislature. The consequences of petitioners' aggressive theory would be drastic. State legislatures would be able to draw districts that protect parties and incumbents so that the people have no realistic recourse at the ballot. That legislature would be unchecked by any other branch, contrary to the fundamental separation of powers principle on which our country was founded and which appears in the test that Governor Schwarzenegger took to obtain his citizenship. You must first enable the government to control the governed, and in the next place oblige it to control itself. And so Governor Schwarzenegger asks the court to affirm the Court of Appeals judgment, which would have been in favor of respondents, not petitioners. So while dry and difficult sometimes, the topic of voting is fundamental and core to American democracy. Well, really democracy any place, it's kind of in the name. But it's core to our principles of the US Constitution. And we do have these 50, 51, 52 experimental territories that are governed by the federal constitution, but only so far, limited by the 10th Amendment. Any powers not given to the federal government are left to the states and the people. So the federal government should be limited. It should have limited power over how states implement their elections, but states should have to implement those elections in some free and fair way. Do we just stop at the words free and fair, and anybody who can make a conclusory statement about what's free and fair wins? No. We look into the history of how we define free and fair. One of the things with the law that you may have noticed is that words have more meaning than just their dictionary definition on the page. So, in my opinion, Governor Schwarzenegger is 100% correct here that the court, the Supreme Court, should follow its prior precedent, and it should uphold the ability of state judiciaries to regulate state legislatures when those legislatures violate the state or federal constitutions. Let me know what you think in the comments below. Did you learn anything from this? Are you eagerly awaiting the outcome of this, or was this one of those videos that you just couldn't get through? Let me know what you think. Of course, I'm asking you at the end of the video if you got through the video, so I didn't think that one through. Thanks for watching. Special thanks to my top supporters in November: Eevi, Spirit Bear, Ugly Grill, Torpedan, Gutbrodj, PureMagma, Eric Tams, TechTechPotato, The Blood-Soaked Survivors, King Aries, and Kyle Siefring. You can support more Lawful Masses videos on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Join me for my weekly live production stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.